Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Dill, and I'll be the presiding judge today. To my right is Judge Wood, and to my left is Judge Tom Murray, and I'd like to extend a special welcome to Judge Murray. This is his first argument. He just recently elected, so welcome to the court. I'd like to thank Delana McCaskey for being our clerk today, and for Tom Slew for being our marshal. We have one case on the calendar today. It's State versus Peters, and if the appellant is ready, you can go ahead and proceed. And let me know if you want to save any time for rebuttal.
Thank you, Your Honor. Yes, I would like to save 5 minutes for rebuttal.
Okay.
May it please the court, my name is John Corella. I am a member of the bar from Durham County, and I represent the appellant, Ms. Sasha Peters. We're fortunate to have Ms. Peters here in the courtroom with us today as well. Officer Boone violated Sasha Peters' Fourth Amendment rights when he searched the interior pocket of her wallet without a warrant, without probable cause, and without asking for consent to search the wallet. In response to Ms. Peters' motion to suppress, the state attempted to meet its burden to show that the search was lawful using the following logic. 1, at some point, the wallet had been in Ms. Peters' car. 2, at some other point in the last few days, Tyrone Thomas had driven Ms. Peters' car. 3, therefore, in the state's reasoning, although Ms. Peters owned both the wallet and the car, when Tyrone Thomas told Officer Boone to go ahead and search the car, his consent was sufficient to allow Officer Boone to pick up the wallet from the roof of the car and rifle through every pocket. This court should reject the state's tortured theory and enforce Ms. Peters' constitutional rights. The questioning of Officer Boone on page 12 of the transcript should have been sufficient to resolve this case. Ms. Peters' counsel asked Officer Boone whether he had asked for consent to search the wallet, which on that page is sometimes called a purse, sometimes called a wallet. Peters' counsel asked whether he asked for consent, and Boone said a clear no. He didn't ask for consent to search the wallet. He also testified the wallet was outside the car, and he didn't know how it got on the roof of the car. The search was a violation of Ms. Peters' well-established, reasonable expectation of privacy in her personal effects, this very personal item, her wallet, which she had earlier in these interactions, if the court has watched the video, been holding the wallet, pulled her identity out of it, her ID card. It was certainly an item in which she had an expectation of privacy under established cases, both U.S. Supreme Court and our state Supreme Court. And she'd shown her possession and ownership of it. What I'd like to do, I think that actually is in a sense, the simplest resolution of the case, but what I'd like to do is address the two different strands of the state's, the theory.
Well, is there an argument that she consented by her actions as well? Maybe she provided consent. And I was going to ask you about that because I know that under the Constitution, a lot of our case law, which talks about the constitutional right, you can consent by your gestures. But we do have a statute that I don't know. I couldn't find any case that interpreted that statute whether that was the statute says consent means to give verbal permission.
Yes.
So is that statute more limit? Does that limit more what an officer could otherwise do under the Constitution? Because under the Constitution, consent can be nonverbal.
I think there are some ways that the statute is more limiting. Yes, and
so you'd say North Carolina law is more limiting than generally. The General Assembly intended to limit the search, the consent requirements.
Yes, I think they intended to limit it, very specific about who can consent and the scope of consent.
Well, I'm talking more about the definition of consent, because consent can be implied or
yes,
nonverbal, but the statute defines consent specifically as a verbal permission to the officer. It doesn't exclude other types of, it doesn't necessarily by its language exclude other types of nonverbal, but it does define consent.
Yes.
The statute says that you can search if there's consent's given, and consent is defined as verbal, a verbal assent to the search.
Yes, and I think that's consistent with both our state Supreme Court's law on this and also a lot of the U.S. Supreme Court cases that come up. I mean, the questions that come up in terms of consent often have to do with exactly what language is used, go ahead or that's okay. But consent does require more than just getting out of the way. The case that the North Carolina Supreme Court decided most recently in 2020, the State v. Reed case dealt with that. It was really about the voluntariness of consent, but it was finding that there was not consent from in that case, the defendant was sitting back in the patrol car and deferred to his wife, who was sitting in the passenger seat of a rented car. And the officer went up, and the officer's testimony was something like he asked for consent to search, and she got out of the car, I think to allow me to consent, allow me to search. And the court was unwilling to interpret that as a consent to search, and certainly not a voluntary consent under other issues that were.
Now, I read the order. Did the trial court in its order, suppression order, denying the suppression, ever make any finding regarding whether consent was given to search the wallet? Because all I saw was there was consent given to search the car, and the wallet was outside the car. So the court never made, as I could see, any finding regarding that one way or the other.
That's correct. The trial court's finding was that the consent was to search the car, and
there was nothing. She wasn't convicted for anything that was in the car.
No, the officer did not find anything in the car. The court actually stopped watching the videos after like the first video and a half, because at that point the wallet is searched. Before he opens the car at all, Officer Boone walks over to the top of the car, pulls her wallet, and then just starts going through. And that is the only point at which anything was found. There's then video of a lengthy search of the car itself, in which the officer finds nothing. There's nothing at issue from inside the car in this case.
Where was the wallet again?
It was on the roof of the car.
Okay.
Now, sometime prior to it being on the roof of the car, you see in the body cam footage that she actually had it in her possession.
Yes, that's correct.
So you know at what time it went from her possession to the roof of the car?
I have watched these videos quite a few times, and it is not clear from the video at exactly what point the wallet was placed on the roof of the car. Officer Boone is turning back and forth. This is an extended interaction. It's much earlier when she withdraws her identity from the wallet. Also in between then, she's handling papers. She's showing him the title to the car that she owns. And then at some point, the wallet is placed on the roof. And it is not clear from the video at all. And Officer Boone could not testify to when it was placed on the car.
Do you think Ms. Peters had the sufficient opportunity to object to the search?
No. Certainly, the search of her wallet, there was no indication that a search of her wallet was about to occur, so there was no opportunity at all to object to that search. And to the extent we're talking about Tyrone Thomas's consent to search the car, I would say the cases that deal with sort of acquiescence by silence by a passenger, et cetera, in the car, all deal with a situation that we don't have here, which is a situation where the person who's consenting is either clearly the lawful owner of the car or the driver of a car that's just been in operation.
Let's go back to that. The
Yes.
driver of the car. So
Yes.
the car was stationary, clearly hadn't been moved recently. So they're not in the vehicle, and the defendant shows the paperwork that she owns the vehicle,
Yes.
but that she didn't have a license. Is that right? And someone else, she'd been letting her boyfriend drive the car for a period of time.
He had driven it at some point. Yes, there was a long narrative. There were a couple stories that they were telling the officer they were asking for help with something that involved Walmart. But in the description, yes, he had driven the car at some point recently, and he said he had been driving it to help her out because of an issue with her license.
And so the court then found that he had control over the vehicle.
Yes.
So explain to me what your issue with that finding is.
Certainly. These control over the vehicle cases come from, and actually, let me, Judge Dillon had mentioned the statute. the words of the statute are actually helpful here in 15A 222-2. Consent can be by the registered owner of a vehicle to be searched or by the person in apparent control of its operation and contents at the time the consent is given. This statute envisions a person who is in apparent visible control of the car when consent is asked for. And that's what the cases are really discussing, is that when there are several people in a car and the driver gives consent to search, and clearly the driver's, without knowing whether the driver is the owner of the car, the driver's ability to consent is derivative of the owner's. We have to assume, assuming the driver is in lawful possession of the car, that person has control over its contents, and even if the owner is in the car, is expected to sort of know that that person can consent. Well, that's not the situation here. That he was not in control of driving the car had not been given into his possession where it's out on the road, and he is in control of the car and all of its contents to the exclusion of Ms. Peters. No, this was a car to which she had title, which was parked. They weren't in the car. They were in their tents or in the woods, and then came to talk to the officer. So he does not have, within the meaning of the statute or under the constitutional law, apparent control of the
Does any of that matter? Because the wallet was not in the car. So is the wallet, if she had given consent, you may search my car, would you concede then that that would give the officer permission to serve a wallet sitting on the roof of the car?
I would not concede that.
Okay,
I think we would still be here today having a sort of a clearer argument, because there would just be one thing to contest instead of two at the same time. But yes, I think that.
So if I were to assume that the wallet is not part of the car, then I've got to figure out, one, the trial court never made any finding regarding the wallet. So on that basis, it would appear that we would at least have to send it back for findings. But then I guess I'm stuck with the question of, was there enough evidence from which the court could have made a finding that she consented? Was there evidence that she had, when he said, I'm going to search the car, that she had gone in there and taken stuff out, like pill bottles and stuff, but then,
Yes.
And could it be inferred that she also then left the wallet on the roof of the car? Could that be considered some sort of like implied or by her actions consent? I mean, the court made no findings regarding that.
Or what happened, she was holding the purse, consent was provided, and then she put the purse back on top of the car after consent was provided by the driver and she didn't say anything. That seems to me what might have happened based on how the video went around the time Officer Boone asked for consent. The driver who was in control provided consent. Your client said nothing, and at one point she was holding the purse because she provided ID and a card for the needles, and then the purse ended up back on top of the car. And I think that's where Judge Dillon might be going, is we had a good conversation about the prescription and why she had needles in the car and all these different things. Purse ends up back on top with no objection. I think we're just continuing their interaction. That seems to be a consensual interaction with questioning and a subsequent search of the vehicle.
Okay, well, let me, I think I can unpack a couple parts of this. So, we aren't dealing with a case of consent to continue a stop or consent to have a continual operation. This is specifically about consent to search. And I think that the issue, regardless of putting aside whether Tyrone Thomas had any authority to consent to the car, but let's assume that he had some. Then what we have is, and by the way, I would just say I would dispute the interpretation that she said nothing, just based on the transcript of the findings and the video. She does say something. It's the court could not determine whether.
That's correct.
No,
and neither could I. It's
exactly.
neither yes nor no. I would interpret
Right.
as she said hum, and that's neither a yes nor a no.
That's correct. That's correct. What this comes to then is this has to be looked at through the lens of consent and the scope of consent. And Florida v. Jimeno is sort of the seminal case about this from the U.S. Supreme Court, which is that the test for the scope of consent is objective reasonableness, which is what would a typical reasonable person have understood by the exchange between the officer and the defender, the person who is searched. We're not looking from the officer's perspective. It's very specifically and I'm quoting here our Supreme Court's decision in State v. Stone from 2007, the reasonable expectations of a person in the defendant's circumstances. What should a person think based on what the request to search was? And some of these cases, say the Jimeno case, there were officers who pulled over a car on the road and specifically said, we are looking for evidence of narcotics. And then the question was, well, does that extend to allow them to look at a paper bag on the floor of the car? And yes, because that reasonably makes sense. So in here we have to look at the exchange. And this exchange really could not have been more vague. The officer has, they just discussed a number of things over the time they're there, including the needles, which she has, they're insulin needles for diabetes, and she shows him her card. She pulls other medications out of the car. The officers are talking about chopping wood. I think it's also notable that the officer in this case is a North Carolina Wildlife Resources Commission officer. So when he asks, the question he asks is something like, is there anything in the car we need to know about?
And they both said no. Both of them verbally articulated.
Yes,
there's
she
nothing
said
in
a
it.
clear no to there's nothing in the car you need to know about. And of course, the question is what does the officer need to know about that's in the car? This is an officer whose jurisdiction includes, finding people who've been harvesting ginseng out of season or poaching foxes or anything like that. And there's no specificity as to what he's trying to search. There's certainly nothing specific to searching the wallet or identity or anything like that, and it's not in the car at the time that he's searching. So a reasonable person in her circumstances would not have thought that the scope of this consent, this go-ahead to this question, would have led to what happened, which was a very specifically walks over the top of the car, picks up just the wallet without entering the car at all, and just goes pocket by pocket until he finds something. That is not what was envisioned, what a reasonable person would envision from the consent in this circumstance. And that's the lens through which we have to look at it under our case law.
And she had no duty to say, I didn't give you permission to search that. You're saying as long as she did not give it.
No, and the cases are clear that it is not, there's not a duty to, simply the Reed case and others that just, consent needs to be clear.
Let's say you're a guest in my house and a cop comes over and says, I want to search your house, Judge Dillon. And I'm like, yes, you can search the inside of my house. And you're my guest, and you just leave your wallet in there, and we both walk out. I would say that you probably have consented they can search that. But if you left your wallet or briefcase or whatever you have on the front porch of the house, would that give the officer, because I'm trying to think of it something analogous.
This gets into another area, but there are actually
have you consented by leaving on the front porch and then walking away?
Yeah, in the case law, let me see, which case was about the room? There are cases dealing with this property circumstance where something is located. Here's an example. The State versus Cook case, which was about a suitcase that was, there were some officers basically looking for drugs in the Charlotte airport, and there were two co-defendants, and one of them left his suitcase with the other, sort of disclaimed ownership but never consented to search it, and the other one didn't consent to search it, and the officers were not able to search that suitcase. Basically, the person who was remaining could not consent to search that suitcase when he admitted that it wasn't his, right? Couldn't give consent to search someone else's suitcase, even though it was in his possession. And I think there are similar cases where there is a dispute about officers get consent to enter a house, but there's a particular room that a defendant has possession of, and there's a separate question of whether they have consent to enter that room.
So is the trunk part of the car? I'm
It
trying,
may be, yeah, so.
the wheel well of the car, a wheel well of the wheel wells.
Sure.
Is that part of the car?
The question, this can't be answered in a technical way or in the way that we use it when we're looking at reasonable suspicion and probable cause, right? It's a different test with consent. Whether, because we're not looking at what's a piece of the car, but what's within the scope of consent. And so the cases, I mean, there's some discussion of these hypotheticals in the United States versus Ross case, right, which is about, it's not a consent case, but it's about the ability to search containers. And Justice Rehnquist goes through these hypotheticals and says, well, it depends what you're looking for. Like, this is a little bit different test for this, but it depends what you're looking for. If you're searching for someone who's in the country illegally and you're wondering they're being transported, then you don't have probable cause to search a suitcase. If you are searching for drugs, it is a different story. If you are aware of, if you have suspicion to search a suitcase that ends up in a car, it doesn't mean you can search the whole car, et cetera. Now here we're even looking narrower than that because it's about consent. What rights did the person who said that the search could be conducted waive? What would they have understood their rights to waive? I gave this court in a memo additional 30, the State v. Person case from 1998, which has a very short discussion of consent, but I actually found it very helpful because in that, it was a situation where there was a written consent to search the car, but then the officers went ahead and frisked the person who was outside the car, not based on reasonable suspicion, nothing else, just based on consent to search the car. North Carolina Supreme Court said, no, that's struck down, cited the statute in addition to other things, and also said there must be a clear and unequivocal consent before a defendant can waive his constitutional rights. So we're in an area where, I mean, we're talking about a waiver of our core rights under the Fourth Amendment, under Article I, Section 20, and about the statutory rights that the court has laid on top of that. You know, waivers are generally construed narrowly, and consent is a form of waiver. And I think that the cases are very consistent on that. Jimeno case uses the term, expressed object. A search, the scope of a search is defined by its expressed object. That's how we determine how far the search can go. Also, just note that the statutes, there's 221, 222 is about the who can consent, and 15A 223 is about the scope of consent. It's cited in the Person case. And it says, a search conducted pursuant to the provisions of this article may not exceed in duration or physical scope the limits of the consent given. And so it's clear that people can limit their consent.
Let's assume I agree with you that the wallet's not in the car, so it's not part of the car, so whatever Mr. Thomas did is sort of irrelevant. It's whether or not she gave, through her actions, consent. If we send it back, is the state allowed to put on more evidence to try to show that she consented? Like, could they put on evidence that the cop now all of a sudden remembers, oh, yeah, she did put that wallet on the car, or whatever? Or are they stuck with the evidence? Is the trial court judge just stuck with whatever evidence was presented at this motion to suppress? Because it's not like jeopardy attached, because there wasn't a trial.
Yeah, I don't think there'd be a basis for having new testimony, since the trial court already had. I mean, I think in this sort of situation, if there were any remand, it would be for the trial court to make findings based on the
evidence that was before.
Based on the evidence that was before it, and I think that's generally what.
Which would be the officer doesn't remember anything and all that.
He does not.
So if the officer all of a sudden.
I mean, I think if there had been a finding, so I do want to say we challenged several findings of fact here, and had there been a finding like that, I would have challenged it as unsupported based on the record, basically, that. And we did challenge the finding of fact as to when she put the wallet in the car, because the trial court indicates that the wallet was placed on the car.
Well, if I were to agree with you that the wallet's not part of the car and the judge made no findings regarding that, I think I'm stuck with, is there enough evidence from which the judge could have made that finding? And so.
That she consented to.
Yeah, to the search of the wallet. And if I don't think that, is the remedy, it just goes back and you can't use the wallet, whatever was found, or is the remedy go back and the state can put on more evidence to try to show that she consented through her actions?
Well, I think in this case the remedy would be I mean, I think it would be, I believe this court could find that there was no support in the record for consent, because there simply is no
In which
evidence
case, the
of a
state's
consent.
not, in which case you're
it's
saying
not, right, the
the
trial
state
court.
can't try again. Okay, you got like 30 seconds before you eat into your 5 minutes, I'm sorry.
Okay, no, that's fine. I'll just reserve my remaining time. Thank you.
Thank you. Good morning, whenever you're ready.
Good morning. To this honorable court, my name is Christine Wright, and I represent the state of North Carolina. The scope of the search is generally defined by its expressed object. In this case, the term of the search's authorization were simple. Tyrone granted Officer Boone permission to search the car, and he did not place any limitations on the scope of the search. Ms. Sasha Pierce consented when she did not speak and say no. Her consent is implied, and implied consent is valid consent. The object to be searched, the car, would reasonably include items inside the car and items outside of the car. This is supported by case law. In Florida v. Himeno, the court found that the paper bag that was inside the car was reasonably an item to be searched because the general consent that was given to the search would include contents in the car that were in paper bags and so forth, as well as items that were in plain view. As in the case law that has continuously said that when valid consent is given, this would include the object to be searched, the car, as well as contents in the car.
But the wallet was not in the car, so this case is a little bit different. So explain, are there any cases that support this type of stuff, type of search?
Sure. Okay. In light of the fact that the court acknowledges that this case is different, then let's look at the implied consent. At no time did Ms. Sasha Peters say, "Do not search my wallet."
Well, she's not required to do that, is she? I mean, she isn't required to say, no, you can't search. The officers have to actually get consent. Isn't that how it works?
When the car was being searched, a person who has a reasonable expectation of privacy, what would they do? Would they put a wallet on top of the car, or would they hold that wallet close to them? Ms. Peters put the wallet on the car, which will lead a reasonable officer to believe that the wallet was included in the search of the car. And this also goes along with her own testimony. If you look at the record, several times Ms. Peters stated to the officer on the body camera that I bought the car and I haven't cleaned it yet. Based on the testimony, the messy car idea is not something that's just something invalid that the state came up with to try to convince the court to go ahead with gleaming from that consent was given. Not one time, not two times, but three times, Sasha Pierce stated that she had just bought the car and she just wanted to pick up her things. Some things were on the floor, and this was prior to the officer searching the vehicle, in which the state argues that she did give consent to. The most telling portion of the video is on video 2 at 7:11 through 7:28, right as Officer Boone was conducting his search. And on the video, you can see that Ms. Peters was going through the car picking up things. Defendants said, at that point, I want to pick up my things because some needles were uncapped. And Officer Boone's response was, I'll be cautious. I will not stick my hand in places I cannot fully see. There is absolutely no evidence here that the defendant was moving items around her car because she did not consent to the search, but to the contrary, by defendant's own words, the evidence support that defendant began to move things around her newly purchased vehicle because, as she stated, I just wanted to pick my things up. Some of them were on the floor. So there is evidence of consent. It's implied. We could not hear her say no, but what we can hear her say through the evidence and her own actions, yes, yes, yes.
But the trial court found Ms. Peters did not object and to the search of the vehicle and impliedly consented to the same. So let's assume that I believe you, that there is enough evidence from which the court could find she consented to search the wallet. My problem is the court never made a finding on that because the wallet was outside the car. Maybe she did consent to it, but doesn't the trial court need to make that finding?
I believe that the trial court relied on the cases that were in its order, which says that, give me a second to pull up that case. In Florida v. Jimenez, reasonableness of containers in a car would equate to the same as a wallet on top of a car. The object of the search is the car. So when the court said that the search was valid, the court assumed that it would be the context on the car and in the car based on what was seen on the video and what was said.
Where is that in the order? I'm just looking at the order because that's what the court found. I can't. It's page 31, 32 of the record. I just see a lot about him consenting to the search of the car and all that. I just don't see anything about
Sure.
that would equate a wallet outside the car would be equivalent to the car. I'm not saying there's not enough evidence from which you
Yes.
could make that, like you're arguing, one way or the other, but the court's got to make a finding on that. How do I know that the finding about the car includes the wallet on top of the car?
Sure. In State v. Washington, the court relied on, of course, consent given by Tyrone Thomas. That's in order. Also, State v. Foster, the court also relied on the fact that consent can be inferred by silence.
I understand that, but I don't see where there was consent given to search something outside the car.
Mm-hmm.
There's a finding on that. I'm not saying there wasn't enough
Sure,
evidence,
sure.
but I don't see a finding
Yeah.
on
I would argue that consent to search inside the car would be equivalent to search of the wallet on top of the car. I can't say that I specifically see that in this order, but I can say, based on the case law, it wouldn't be an unreasonable inference to say that if valid consent is giving or general consent to search a car would also include contents inside the car as well as on top of the car.
Well, let's talk about that, what the scope of the search was. The officers asked, is there anything in the car we might need to know about? To which they responded, no, and they said, do you care if we actually check? So it would seem by their words that the request was to search the inside of the car. And even if there was consent, it doesn't seem to be, yeah, go ahead and search the car. It seems to be search the inside of the car. So would you contend, though, that the inside, the scope is still the entire car inside and out, even if the officers only asked to search the inside of the car?
The scope would be the entire car.
Did the officers just say, I want to search just the inside of the car?
The officer didn't say it would just be inside of the car, but the object is the car. It would not be unreasonable, especially based on these circumstances. You have a person that was taking things out of the car, placing it on top of the car, putting it inside, tidying up. Not that she was not consenting to the things that she was putting on the car, but she was moving things around to assist the officer. It's the state's position that she was assisting the officer after she consented to the search because there were needles and she didn't want him to harm himself. So it would be reasonable to say that the wallet, even if it was in the car, was taken on it, would be included in that search.
Well, now, originally, the wallet was not in the car, correct? She had the wallet on her person, and she took the ID out and showed it to the officer. And we clearly see it in her hand. The question is, when did it get on top of the car? But it wasn't actually in the car initially, isn't that correct? I mean, do you concede that?
Yeah. I can't say for sure if she ever put it in the car, but I can say that we're unclear as to at what point it got on top of the car. But again, she presented the wallet to the officer to show that her title was good. She heard Mr. Thomas say the car would be searched. Again, it is the state's position that the search would have included the entire car, and if she had a reasonable expectation of privacy of that wallet, why would she put it on top of the car?
So let me ask you, can you distinguish this case from State v. Ladd? And in that case, it didn't involve a car, but it involved search of a laptop. There was a laptop bag, and inside the laptop bag were 2 hard drives, and the officers asked for consent to search the laptop, and the officers did search the laptop, but they also searched the hard drives that were in the same bag. And it would seem a reasonable person might think, well, searching the laptop and the hard drive, since they're all in the same laptop bag, would be reasonable, but the court said no, absolutely not. The consent was limited to just the laptop. Can you distinguish this case?
Yeah, the consent in this case was the car. And I think this case is different from that case. We're not talking about there was nothing that was intrusive about going into the wallet. In this case, there was nothing that was separate and apart from the car. The wallet was attached to the car. We're talking about the same car. We're not talking about a different drive. We're not talking about a different suitcase that another laptop was in. We're talking about the same car and the contents inside of the car and the contents on top of the car. It's the same car. So it is different, respectfully, in my opinion.
Do you think that the defendant had a sufficient opportunity to object to the discontinuing of the search or any portion of the search?
Yes, absolutely. I believe she had plenty of time to object. She engaged Officer Boone several times. He gave her instructions as he was doing the search. Ma'am, it's okay, you don't have to do that. When he took the wallet, she could have said, no, that's not a part of it. Just like she said she was moving things around in her car to tidy it up, she could have easily said, please do not touch that wallet. But she did not do that because it's the state's position that she had consented wholeheartedly to the search.
Thank you.
In conclusion, I would just like to end by saying that again, she consented by not saying anything. Her actions show consent. She was not protecting her right to privacy. How do we know this? Because she put her wallet on top of a car that Officer Boone was searching, was giving valid consent to search. She knew the car was being searched. She took no steps of protecting that wallet, but she included it somehow in this search. And a reasonable person would not have left their wallet on the car if they did not want it to be searched under these circumstances. Thank you.
Thank you. You've got about 5 minutes for rebuttal.
Thank you. First, I just want to go back to something I mentioned during the main argument because I found the case I was talking about was State versus Smith, 346 NC 794, which is cited in the briefs. That was the case I was remembering about going into the house and the difference between consenting to entering the house versus the particular room. I think the Ladd case that Judge Wood mentioned is very helpful for illustrating that this isn't a proximity test. This isn't a sort of, was it around the thing? It is a question of the scope of consent. And it is, again, going to be narrowly construed as to what the person would believe they were consenting to. Cases that deal with the failure to object or consent by silence are all cases in which there is already some kind of lawful consent, and that the search that happens is within the scope of that consent, which I would say is not the case here. I mean, one, and we haven't really discussed this much, Tyrone Thomas did not have authority under our statutes of the law to consent to the search of the car, and that is an issue in this case. And for that, I would actually point primarily to the case of State versus Washington, which is cited in the trial court's order. That was the case in which there was a car at this property that was the defendant, Mr. Washington, had bought the car and was apparently the exclusive driver of the car. Not just that he drove it sometimes, but he was the only one who drove it. However, his mother was the registered owner of the car, and she consented to have it searched. And the court said not only was her consent proper, but I think another helpful thing that comes from Washington is the court went on to say, under the statute, since he was not driving the car at the time and was actually, in a squad car or something at the time, he was not the appropriate person because he was not in apparent control of the car, because he wasn't driving it then. And that's what we have here. The fact that Tyrone Thomas may have been given license to drive this car at some point by its owner, Sasha Peters, does not mean that when he is not driving, he can consent. And because if that consent's no good, then we don't even need to get to the question of her, she can't acquiesce by silence in an unlawful consent. I mean,
But she did more than that. I mean, I'm trying to think of the light most favorable to the state, and tell me if I'm wrong about the way I understand the facts. She had her wallet in her hands. There was this consent to search the car, so in her mind, she knew the cop was going to go search the car. Whether he had the right to do so or not, they didn't find anything in there, so it doesn't really matter, at least in that narrow circumstance. She then goes in her car and takes stuff out,
Yes.
and then somehow the wallet gets on the top of the car. Whether she intended to do that or she just put it up there to clean it out, I think it's unclear. But and then she walks away. So in light most for the state, why wouldn't it be that, okay, I know you're going to search the car. I'm going to take some things away, but I'm going to leave the wallet on top of the car and then walk away. Why through that action would that not be enough to give that wouldn't show some sort of consent? You can search my wallet because I'm going to leave it here and take all this other stuff away because I know you're going to search all this stuff.
So first, I would just point out that we're dealing with something where the state's got a burden of showing a lawful search. This isn't a sort of sufficiency case where we have the
And it's through her consent, her actions, and like, I know you're going to search this area over here. I'm going to leave my wallet on top of the
Yeah,
car
and there
and
are-
take everything else away.
Multiple cases. Again, we're putting aside some of the lawfulness of consent for a second, but showing that just getting out of the way is not enough. That's what the State v. Reed case from our Supreme Court says. The Pearson case, that the fact that a person is in a situation and they feel like they have to comply to being frisked, right? The defendant in Pearson didn't object to that additional search, but it wasn't lawful. It's beyond the scope of his consent. So if it's beyond the scope of the consent, we don't require an additional objection. And if we don't require an additional objection, we can't interpret her actions here as some kind of assent to a search. The scope of the search, even if it was lawful, which it was not, was inside the car. The wallet was not inside the car. It's not as if she placed it there inside the car. And we don't have evidence that she even placed it there at this time. It just ended up there at some point during the interactions that happened. The officer could not say when, and he did not base his actions on any observation of her doing it.
If you want to take 30 seconds to wrap up here, feel free.
Okay, well, I mean, the last thing I would just point out is that, Officer Boone asked another question that we haven't discussed in the video. After asking about searching, he asked, do y'all need some help? And to that question, she gave a clear yes. And instead of getting any help, what she got was an intrusive and unlawful search of her wallet and arrested. And I hope that this court can do better and vindicate her rights under the Fourth Amendment and reverse the trial court's denial of the motion to suppress. Thank you.
Thank you for your arguments. We will take it under advisement, and we will adjourn.